UKIP friends, welcome to all my new listeners to episode 69. Episode 69, guys. We are getting closer to episode 100. There's a 100th episode. So if you are a new listener, thank you for listening. Thank you for subscribing. Thank you for sharing, liking. What we do here is talk about everything intellectual property, from copyright, trademark, patent, industrial design, trade secret, geographic indication, and plant variety. I mean, basically, recent cases and development as our case study for today would, give you an insight as to why I do what I do. For my returning listeners, thank you guys for always sticking by me, for the support, for the love. I do appreciate, and I do not take it for granted. And on that note, I welcome you to our conversation for today, which is basically about how to cancel a trademark. I'm going to begin with a story of how I became aware of this case. So I am on an intellectual property group called IP Radio, which is owned by Mr. Nosa. You guys should check him out on LinkedIn. He organizes a lot of intellectual property events, webinar. My team and we've collaborated with him on I think when we had our first IP conference, maiden conference virtual. So he's Mr. Nosa Hari Uwadia. Check him on LinkedIn, follow him. He has very useful content there. He also has a webinar coming up sometime this month, so be on the lookout for that as well. But someone shared a document. It was a 45-page document on the group. And I was like, interested. And I think the first thing that caught my attention was the Shakara. I was like, Shakara in a trademark dispute that we are not aware of. So I just started reading it. And I was like, oh my God, what the hell is going on? Sorry, guys. I shouldn't be using swear, but I was like, what is going on? So it turns out that the word Shakara kind of like in a dispute. And then I got another publication by the World Intellectual Property Review, where they're like, Shakira finally gets partial victory in her trademark cancellation for the word Shakara. So WIPR were people that named in 2020 named me as the WIPR influential women IP trailblazer, and that was like my first international recognition. So I was blown by that. But yeah, I subscribe to their content. So if you want to get IP highlights, IP news, subscribe to their blog. They share lots of content. So I saw that message and I was like, ooh, something is really going on here. So as we know, trademark as a form of intellectual property mechanism protects the uniqueness of your name, your logo, sign, symbol, and non-traditional marks or patterns, and all of that gives your brand an edge in the market. And I started to read this and I was like, So I had stated that my topic for today is grounds for invalidating or cancelling a trademark, but here's the summary of the case. So the story be say Shakira don't stop person for Obodo Yubo UK from using the word Shakara because people they confuse Shakira and Shakara. So she applied that the mark be cancelled or invalidated. And I was like, this thing makes sense or makes sense because guy waiting this up. Like, what is really going on here? So turns out that Steve Uzoma Nwankpa had began his application for trademarking the word MyShakara in class 18 and class 25 sometime September 11, 2017. So class 18 basically covers leather imitations, travel goods that do not include other classes, and class 25 for clothing, footwears, and headgear. Now he completed this registration um on the 19th of January. So let's see, from September to January. September to January. That's about 4 months. Yeah, about 4 months. With his registration number as 3,256,004. Remember that trademark is territorial in nature, and the steps to registering a trademark is: you first do a search, you carry out a search and confirm the availability of your mark in question and in the class that you want to register is. Once that is done, you file your details, then you wait for an acknowledgement. After filing, then you get an acceptance or a rejection letter, as the case may be, after your application has been reviewed. Then you wait for publication in the journal. Statutorily in Nigeria, timeline for that is about 2 months from the date of when it was published in the journal. And then if you're successful and no one opposes it within that 2 months, you apply for your certificate. It's supposed to be easy, right? Like, just run through all of these 7 steps and boom, you have your trademark. But then 4 years later, on the 15th of April this year, Shakira Isabel Mebarak, who sang the famous "Whenever, Wherever" or "When My Hips Don't Like," I don't know how to sing, guys, but I do enjoy karaoke once in a while. So she filed an application to declare Steve's application of MyShakara invalid on grounds that they were highly similar to her own trademark Shakara in class 25, and that there was a likelihood of confusion on the part of the public in the United Kingdom. She also relied on Section 5. This is funny. Yeah, so get used to it, guys. I'm going to mention a couple of sections. I mean, if you follow my content, I always like to cite the law to back up my conversation. So yeah, she relied on Section 5 sub 2 paragraph B and Section 5 sub 3 and Section 5 sub 4 paragraph A of the UK Trademark Act 1994, which talks about relative grounds for refusal of registration. So I did a screenshot of that, but don't know, should I read this now? Anyway, so page 2 of the document that was shared, that's like the decision of the UK Intellectual Property Office, reads that the applicant relied on the same mark under Section 5 sub 3. She also claimed that the mark has a reputation for class 25 goods relied on under Section 5.2 Section 5.2 paragraph B, and also the following services in class 41 for entertainment services in the nature of live performances, music publishing services. She further claims that the use of the contested mark would, without due cause, take advantage of or be detrimental to the distinctive character and reputation of the earlier work. Then it goes further to say, under Section 5 sub 4 paragraph A, the applicant claims to have used the sign Shakira throughout the UK since January 2000. And this is 2022. So this is about 22 years that she has been using the mark. So take note that when you register a trademark, you also have to pay the renewal fee. If you haven't been paying, or if you've never paid, please verify for your trademark agent if you're due for that and do the needful. So it just basically reads that Shakira has been using the sign Shakira throughout the UK since 2000 for the following goods and services: clothing, headgear, bandanas, scarves, bags, jewelry, CD, recording of music, DVD, recordings of music and of live and recorded music performance. It's a long list, guys. So entertainment services in the nature of live or recorded performances, Entertainment services in the nature of films featuring the applicant and her music performances and other matters related to the applicant. The applicant claims to have acquired goodwill under the sign. Goodwill is a good thing when your goodwill reputation kind of helps you when you have like a passing of passing of case in the event that your mark is unregistered. But then you can also plead that for registered mark as well, just to show the court the impact that your brand has resonated with your consumers. So yeah, that's about that. I was gonna read section 5 of the UK trademark law, but I'll just give you like a brief highlight. It says relative grounds for refusal of registration. One, the trademark may not be registered if it's identical or similar to another mark out there, which I know I've alluded to previously. Then as a consumer, so I like I said, I always like to do polls. So I asked my IP friends, would they confuse Shakira mark for clothing and headgear for Steve's MyShakara boutique that sells products reflecting African tradition and culture in the UK. Presently, 88% have said, or 88% have said no. 13% have said yes. What does it mean for a trademark to be invalidated or cancelled? Now, the UK Intellectual Property Office has defined it to be a legal procedure to cancel a mark based on it being invalid or not distinctive or too descriptive, or on grounds that there has been an earlier mark registered with that name and in that class. If you also wish to cancel a mark, you will need to apply to cancel or either invalidate the entire registration or some part of the registration. So, for instance, like this Shakira case, she was suing on grounds of being two classes, 18 and 25, but she ended up not getting all. So this is where, when they say some of the registration, she won in some of the issues that she raised for the registration in class 25, but not in class 18. In Nigeria, when you want to apply to cancel a mark, you must do so within 30 days, and the registrar's decision is also subject to an appeal to the court, which in this case would be the Federal High Court. Your application must be brought by way of an originating motion. Talk to your lawyer, please. Attached with the relevant document as part of the record of appeal in Form 23. So you can also read section 40 sub 1 paragraph C rather, and rule 86 of the Trademark Regulation 1967. Now, how the proceedings went was that Shakira applied. She commenced her application that Steve's MyShakara trademark be invalidated or cancelled, and Steve, in his response, denies that the word Shakara was not similar to Shakira, because Shakara is a place and a language spoken by some Nigerians. I wouldn't say some Nigerians, but that was his defense. He said it was a language spoken by some Nigerians, but also a word that was coined by the legendary Afrobeat artist Fela Kuti, and also the title of his 1972 album. So if you know all of this, why go ahead to want to use it? Again, the question would be, did the Fela Kuti estate or hairs commercialize the word Shakara that would require Steve to want to get some sort of permission or license to use the word as the name of his business? But let's move on. He also failed to show and explain why he chose it. Like, why did the name Shakara resonate with you? Why did you think it was like the right name for your business? He failed to show that. He also failed to show prior use. Remember that Shakira had in her application stated that she has been using the word or the name Shakira since 2001. as 22 years ago, and he only just started using it in 2018. Then I then went for to ask, is it possible to sue for someone to claim monopoly or ownership over a word, a name, or phrase that they did not coin? For instance, now Steve did not coin the word Shakara, but went ahead to use to name his business MyShakara. Can he actually sue another person for using the word Shakara? I mean, it kind of reminds me or takes me back to the Yoruba Star case of last year and the whole Timbuktu saga, and you guys know the rest. But according to the poll, 70% said he cannot sue another person over the word that he did not coin. 30% said yes. Then I went further to ask, can the word chakra be considered to be descriptive or generic in Nigeria? I mean, so you hear phrases like, she too they do shakara, your shakara too much, sure, all these kind of things. Is it generic? Maybe, maybe not. But 65% said yes, it is. 12% said no, it isn't, and 24% were like, oh, we own the word Shakara, but you did not coin the word Shakara. So how can you say Nigerians or Nigeria owns the word? Unfortunately, Fela is not alive to claim authorship or ownership over the word, even though he had named his 1972 album Shakara, and he also has a song titled Shakara. Copyright doesn't protect titles or books or songs or phrases or whatever. But if you decide to trademark the words, the phrase, short phrases, you can commercialize it at the end of the day. So that's something that we need to think about as brands or as businesses. I made reference to the Yoruba trademark case, and I asked if this was a similar case to a Nigerian attempting to trademark another word that will be considered to be indigenous to a particular region. 75% said yes. Voting is still ongoing because I can see just 8 votes so far, and 25% said no. And I went further to ask, is the word Shakara identical or similar to Shakara? 21% said hell yes. Why? Seriously, guys. Like, I don't see the similarities because the pronunciation, there's nothing that links the words to each other that would say they are confusingly similar. Can a person see the mark and confuse? Can someone see Shakara and confuse it for Shakira? I do not think so. I mean, they're not even spelled the same way. So things to consider when you're talking about similar marks or likelihood of confusion. One, do they have physical features that are considered to be competing against the other? Secondly, the phonetics, like if you put like Shakira, Shakara, I really don't see the connection. Is the sound really important at the end of the day? Can two competing trademarks be visibly different? Can they be different and then phonetically similar? I don't think Shakira and Shakara are phonetically similar, as the case may be right now. Then I gave her an update. So the update now is that Steve eventually submitted the form to surrender MyShakara to Shakira this year. And Shakira still went ahead to continue with her invalidation application. She was like, she's like, oh, even if you surrendered, I'm still not stopping it. Let's just get it over with. So surrendering a trademark means that the mark can be relied on up to the date of the surrender. The effect is that the mark is treated as if it has never been registered. So when you surrender the mark, it's not considered that you have never even registered. So that means currently now, Steve's registration is null and void. Like, it did not even exist. It never happened. And the final decision of the proceeding, Shakira got a partial win in challenging the Shakara trademark by Steve at the UK Intellectual Property Office for being too similar to her clothing, as in Class 25, clothing, headgear, bandana, scarf, bags, jewelry from Shakira's clothing line, which she argued and stated that she sold them during her tours, but was unable to provide pictures or proof that she actually sold this clothing and headgears to demonstrate that she has some sort of goodwill in that particular class. So I do not really agree with the registry, with the IPO decision to grant Shakira partial win. I think there should be some sort of collaborations, diversity at the registry. Like maybe the registry should consider hiring people from different jurisdictions so that you prevent people from wanting to take advantage of someone's culture or tradition or anything. Because if the Yoruba Star case was not, it didn't go viral, would never have heard about it. This Shakira, I don't know why I don't think people are really aware about the Shakira case, but I think we need to start paying really close attention because we are seeing a lot of that. I know someone has made mention or alluded to the fact that the word Nollywood had been trademarked in the US. Why would you even think of doing that? I mean, but yeah, let's keep it moving. Hey, next up, how do you claim protection for a registered trademark? One, when it's registered in a particular class or a specific line of goods or services under the NICE classification, you can claim protection in that particular class. For instance, now, Shakira registered in class 9, 16, 25, and 41, while MyShakara was registered in just class 18 and class 25. Then proof of initial use against a distinctive character through use, as in this case, Steve didn't show prior use of the word, whereas Shakira showed that she had been using the word or the sign Shakira since 2000. 1st of January 2000 in class 25, which already listed out. How do you then determine an identical mark? So using our case study, you see that Shakira registered in class 25, which is used to cover body parts of the body, or body parts basically, which is similar to Steve's boutique's purpose of providing clothes that cover the body, which could affect the perception of the consumers and therefore also cause confusion based on their connection. So what would consumers' expectation be when it comes to trademark? First of all, you have to look at ease of distinctiveness. Can they see the differences or uniqueness of each of these brands? I mean, can you look at, let's just look at the sign Shakira and MyShakara. What is distinctive about them at the end of the day? Next up, you will consider source of origin. Both Shakira's clothing and MyShakara boutique were for selling products that covered body parts. So class 25 is already like similarities in the same class. The next thing we're looking at the perception of an average consumer. Would they really, if they put the products side by side, would it lead to confusion? Would it lead to confusion if you use the mark with similar meaning in another language or different word mark? Would it lead to consumer will it lead to the point where the consumers cannot differentiate it, or when they look at this side by side they're like, oh, these two brands are really competing, I can't really differentiate between the two brands. Then what can make the registry refuse to register your trademark? This one is very important, which is why you're doing your trademark registration, it's very important you do a proper consultation and make sure you're properly guided. I know someone called me recently. I was trying to verify if her application was genuine because of how the conversation between the agent and herself was actually going. So what the registry will be looking at for, if they are similar or identical, if it's likely to cause confusion, if it's too descriptive or generic, if it's not distinctive enough, and if it was opposed by a third party. Remember, I had stated that At the publication stage, the registry publishes the mark for at least with I mean 2 months in Nigeria, and anyone who has reason to oppose it for being similar to their own mark can do so within 2 months. So read section 20 of the Trademark Act to be properly guided. Another thing the registry will consider is if the mark is too deceptive or scandalous. Read section 11. Then names of chemical substances. Chemistry student, my science student, get in here. Pay attention, no. You don't got register H2O or I did chemistry. Oh. I can't even remember chemical substances, but yeah, you have to take note of all of those things. So you read section 12 to be properly guided. So you don't make that mistake and the registry ends up rejecting your trademark. Then next up we will be looking at functions of a trademark, or things you really need to know about trademark. First of all, when you come up with a name, logo, sign, symbol for your brand, always do a search at the registry. Search is manual and it's online, but it's a bit faster when you do manual. In countries like the UK, the principle of first to use rather allows brands like Shakira to enjoy a fair amount of protection over the use of the mark without actually registering. But in this case, she had registered this since 2001. And one thing you need to know about trademark is that you need to consistently use that mark for commercial purpose. In Nigeria, we apply the first to file system. So if Steve Nwankpa had registered MyShakara boutique before Shakira, then he owns the mark to the word or sign or symbol Shakira. But that was not the case here. They always make inquiries as to the laws of the various forms of IP in the jurisdiction where you are. So yeah, we are about to wrap up. Yeah, but I hope you guys are really finding it interesting, because this was a bit hard for me to do, and I didn't want to sound too biased because I'm Nigerian and I know how the word Shakara has been used. I don't know, but yeah. So in wrapping up, guys, lessons for businesses in Nigeria. If your mark is considered to be similar or identical, the interested party can just know that the interested party can always apply for your mark to be cancelled. When that happens, you might have to defend your case and show that the mark is not really similar. So, for instance, I had referred to the Bentley Motors again Bentley clothing case. I did a podcast about that. I also did a Twitter version about it, talking about what grounds for cancelling a mark in Nigeria. I also talked about what can lead to your mark to be cancelled. So in that case, I'll just do like a brief intro, but you can check out the podcast and the Twitter version. Basically, Bentley Clothing had been using the word clothing for a very long time before Bentley Motors decided to go into clothing, and they applied, for trademark infringement, and it led to, the court ordering that Bentley Motors should destroy every clothing that has the word Bentley on it. So they were fighting over the word Bentley. And Bentley Clothing was relying on their reputation and goodwill that they've enjoyed over the years in the United Kingdom. They also went to show that there was going to be some sort of confusion when brands, saw the two clothing. So they went through a lot to actually prove their case, and the court finally ordered that they should destroy the clothing in the fashion line immediately. So yeah, that one was like kind of straight to the point, but this one is a bit, I don't know, I kind of feel like I'm a bit biased as to the findings of the UKIPO. So if you also want to sue someone for infringement, the ingredient for infringement is that you must show that authorization was not given, and the mark is similar or identical, um, that it's been used for commercial purpose, it's been registered in a whole or part, and then what do you then do in that instance? You talk to your lawyer, your trademark lawyer, who would help you understand if there's really a likelihood of confusion or even similarities between the two. If the marks are confusingly similar, then you guys will come up with a strategy. You then determine the jurisdiction of the infringer. You may also now have to send like a cease and desist letter. If they don't listen, then you file a suit either in the court of in your country, like if it's in Nigeria, Federal High Court, or you opt for out of court settlement. I kind of like out of court settlement, but yeah. So that's like so check out that episode when violation of a trademark can lead to cancellation and deadlines, and when non-use of a trademark can lead to partial or total cancellation or revocation. So when you're not even using your trademark, someone can apply, a third party can apply to cancel or revoke your rights to that particular word. So next up is that make sure you consult with a trademark lawyer or firm or intellectual property lawyer or firm on the basic requirement for registering the trademark in your territory. What impression does your brand want to give, creating the minds of the consumers? Also avoid any form of direct or indirect confusion amongst your consumers. Then the reputation of a trademark must be established by the relevant sections of the public as regards the goods and services for which the mark is registered. Then the more unique your mark is, the greater the likelihood that a similar or identical mark will cause harm to the distinctiveness of the mark. I mean, I think prior to today, I didn't even know Shakira had like a trademark until this case. So how popular is her mark that she would claim that there's going to be a likelihood of confusion or similar, or the marks are highly similar or identical and it's going to cause harm to her and the rest of them. So anyways, this is just my view. So in the event of an infringement or relative ground, follow the channel for resolving such dispute by either challenging the registration or the unauthorized use, or going to court, or opting for out-of-court settlement with the guidance of your trademark and intellectual property lawyer. But then on the final note, I don't really understand why Nigerians in diaspora or Africans in diaspora always see the need to register a word, or a slogan, or a sign, or a symbol, or any other intangible asset that has elements of their culture, or place, or region, or country, just want to monetize and commercialize and be like gatekeepers. I mean, if it's not even yours in the first place to protect or monopolize, or even you've not been chosen as the authorized custodian. For instance, that Yoruba Stars case last year, if that her registration was not opposed, we would never have even heard about it. They're just probably taking it as, oh, just another thing. So I think we need to start waking up, start doing the needful in terms of positioning our intangible assets, our intellectual properties, our creativities, our innovations in the market space that's on the map. Put our brands out there. We also need the encouragement and collaboration and support of the government. We need more industry support. So each industry should have like a structure, an IP structure, have like people who act as middlemen between themselves, the government, and other stakeholders. Then we need more IP awareness, because we can't keep having cases. Who knows? Maybe tomorrow someone will go and trademark. I'm trying to think of a word that is really popular in Nigeria. Okay, let me not even talk about it. But let me not even talk about it, because I was going to mention something. I beg, or guys, let's be more creative, come up with more innovative or colorful words, because we're super talented. We're really talented as a continent. We have what it takes to be like boom, boom, boom. The next Silicon Valleys and the rest of them. We need more African IP standard and structure. We need, gosh, I have a lot to say, but I hope that this case would open the eyes of Nigerians or Africans in diaspora on the need to actually collaborate with the government in terms of, monopolizing elements of our cultures. Also, we need to be more deliberate, have proper structure for our intellectual property rights. So yeah, I hope you learned something. So far, not using your trademark could lead to the registry cancelling your registration if someone applies for it. So make sure that while you're registering, you're also using it for commerce. You are renewing, paying your renewal fee at the end of the day. You have a trademark or an IP attorney on your retainer who will advise you, because IP interfaces with every sector of the industry, guys. Trust me. So yeah, the clothing line, film industry, because this is like IP rights that exist in the film or clothing industry. Sometimes you see, two brands with the same design, logo, and the rest of them. What can be trademark? Your name, sign, logo, symbol, that can be trademark, but it has to be unique. It has to be distinctive. It has to pass the basic requirement of being distinctive in nature. When it doesn't meet that requirement, it's more like you're just fishing. So, and we would not want that for you. So yeah, thank you guys. Thank you guys for listening to me ramble again about intellectual property. Shakira, no, I don't know if I pronounced it or I sang it well, but I had to listen to the song by Fela Kuti, and I would want to also understand Steve's inspiration between choosing MyShakara. I mean, it's a boutique, the sell clothes and the rest of them, but shouldn't you have thought of a better name in terms of right? So yeah, while name, words, phrases can be registered, it has to be coinful, fanciful, arbitrary, not too descriptive, not too generic, But yeah, thank you guys again for listening to me. Don't forget, if you have cases or you want me to talk about something, please share link with me, share story with me. I also want the fan make review. I'm going to do that before the year runs out. Trust me, I will do that. And also the recent MTN color tune, because I also want that as well. I'm going to do that this month or before the end of next month. So yeah, don't forget to like, share, subscribe, and see you guys in the next episode. Mwah.